All right, everybody, it's just about that time. So welcome to another session of our WISE Senior Virtual Connects. Great to see a lot of the same faces and maybe some new names. I can't see all your faces, but I recognize some names. You can feel free to leave yourself without video or start your video. Either way, I'm just really glad to see you guys here this week. Miss seeing you in our space, although I know some people are attending maybe some classes there, and there's definitely online classes to be watched virtually. But I am really excited today for our guest, and you can see her up in the top of your screen. Her name is Kim Gossage. Kim has been with us before. She's with Garrity and Gossage and Matthews, and I think she has spoke about a year and a half ago to our group. So I am welcoming back. Happy to have you, Kim. Welcome so much. Thank you for being here today with us.
Well, thank you, Jane. I'm really excited about it. And thanks to all of you who are taking time out of a gorgeous day to sit here and listen to me talk about powers of attorney. That means a lot to me. So I was here about a year ago, maybe a little bit more than that. And what we talked about then was estate planning documents in general. So wills, financial powers of attorney, and healthcare powers of attorney. And when Jane and I talked about this today, we thought maybe it would be a good idea not to fully repeat that information, but just kind of expand on some of the particulars of it. So my plan today is to talk about financial powers of attorney, healthcare powers of attorney, and then what happens when someone doesn't have those in place, which is guardianship. So before I launch into it, a little bit of background about me and about my firm. Like Jane said, our firm is Garrity and Gossage. We have 4 attorneys now. We are in Matthews. I don't know if you can see much about my background other than my messy desk, but we are in a historic building in downtown Matthews, and we've been here for a few years. We've been practicing together for about 14 years. And my practice is devoted entirely to estate planning, which is wills, powers of attorney, and trust. Also to probate, which is what happens at the courthouse after someone passes away. And then finally, what we call elder law, which includes things like guardianship, Medicaid, some Medicare, VA benefits. So I'm giving you that background because I'm hopeful we can approach this today pretty casually. And if you all have any questions at all about what I'm talking about or something I'm not talking about that you think I might be able to answer for you, please feel free to jump in. And if you're not comfortable jumping in, I'll open it up at the end and take all the questions you've got. Does that sound okay?
That's
great. Excellent. So let's go ahead and get started. I've put together a pretty short, excuse me, PowerPoint that I'm going to put up on the screen here. And but don't take that to mean you can't interrupt. So if you've got questions, you jump in. I'll take it off the screen, and I'll be happy to answer your questions. Let me see. Jane, will you let me know if I did that correctly?
Yes, and go ahead and I see this the sidebar stuff. So click that.
All right. Well, we're just going to we may just have to deal with the side. Hold on, folks. I had this set up before, and now it's not quite working the way I'd like, but we can make it work. All right.
Here it is.
Better?
Yep, perfect.
All right, that's who I am. So we're going to talk first about healthcare powers of attorney. A healthcare power of attorney, in that document, one of the biggest decisions you'll be making is who's going to make decisions for you if you get to the point in your life, either short-term or long-term, where you can't talk to the doctors for yourself. So first and foremost, let me make sure everybody knows that the documents that I plan to talk about today are effective while you're alive. A will only takes over after you pass away, but your powers of attorney are while you're still here with us. But for some reason, you can't make these decisions or communicate these decisions for yourself. So a healthcare power of attorney says, if I get to the point where I can't talk to my doctors for myself, then this is who I want to do it for me. And I'm going to assume that you all already have all these documents in place. So I'm going to give you a few things to go look for when you go check your documents after our call today. When you go to look at your healthcare power of attorney, I would encourage you to have 2 people at least in line to make decisions for you. So if you've named your son first, but he's sick or he's traveling, it's a great idea to have your daughter as a backup so that we know if there is an emergency, someone's going to be able to step up and help you out with this. Excuse me. Know too that the healthcare power of attorney is not just for somebody who's in a nursing home or in hospice or in a hospital. This could be if tomorrow you're having surgery to have your gallbladder removed. While you're anesthetized, someone needs to be able to talk to the doctors on your behalf. But when you come out of that anesthesia, you're in charge again. So this document kind of goes into effect when you need it and comes back out of effect when you don't need it anymore. And the word for that, it doesn't sound like it's a legal term, but believe it or not, it is. That's called springing. That means it goes into effect when you need it, but when you're healthy and you don't need anybody talking for you, those folks have to step aside and you take over again. So far, so good? No questions on that? All right, so by law, by North Carolina law, all powers of attorney have to be springing. That you cannot give somebody your legal authority to manage your health care unless a doctor says you need help to do it. And in fact, you can even pick the doctor who will make that decision. So if you've got a doctor who treats you regularly, maybe your family doctor or neurologist, you can put that doctor down to make the decision. Most of my clients don't. Most of my clients say, I just want to have my attending physician at that time make the decisions make the decision about when somebody can step in and get involved in my healthcare. All right, so moving on. Another thing to look for when you go look at your own healthcare powers of attorney, or if you haven't done them yet, something to keep in mind that we can do for you. First of all, they're perfectly revocable. So if you have one that you did 20 years ago and you look at it and you say, good Lord, everybody I named in here is no longer in a position to help me, or I don't like them anymore, then it's easy to change. We can't just tweak them. We have to actually throw away the old one and do a new one. But a lot of times my clients will ask me, well, what if the folks I named to make medical decisions for me don't live right here in Charlotte or right here in Matthews? What if they live in Massachusetts? What do I do then? Well, it's an unusual solution, or at least the folks who put this together, I think, are unusual to have done it. But our North Carolina Secretary of State actually has come up with a solution for you, and that's called the North Carolina Advanced Directive Registry. Now, on that registry, this is not working the way I want it to. You can file your healthcare power of attorney and a living will. A living will is a completely separate document, or can be, that talks about what treatment you want when you're at the very end of your life. A healthcare power of attorney is for right now. If you have an emergency, that document's going to help you out. Living will is when a doctor has said, she's very ill, there's not going to be any recovery, she's got a couple of hours left to live. That's the difference between those two documents. But either one can be filed with the Secretary of State's office. The filing fee is $10 per document, so it's not an onerous fee at all. It's ideal when the folks that you've named are folks who don't live right here in the area. Because here's the scenario. You fall and you break a hip and you need to go to the hospital and have surgery. That all happens pretty quickly, as some of you may know. If you're not able to talk for yourself and answer the questions that the doctor is asking, or sign the paperwork to have you admitted to the hospital, someone else needs to do it. Well, if you've chosen your daughter who lives in Boston, Massachusetts, then the question becomes, how in the world are we going to get this done when she lives so far away? And that's what this directive registry is all about. So what happens is you mail your documents in, or we can do it for you if you'd like us to. You mail them to Raleigh, to the Secretary of State's office, and $10 for each one, and they file them. They put them in their database, which is an electronic version of it, and they send them back to you. And when they send them back to you, you get these, I wish I had some to show you, they get these great wallet cards back. And the wallet card just says who you are, where that database is located on the internet, and what the passcode is for it. So if you do have an emergency, you're here in Charlotte, but your daughter's up in Boston, she and your doctor can get on the phone together, and they can actually go to the database together and pull up the document, and she'll be able to direct your treatment until she's able to get down here. So personally, not everybody at my firm agrees with me on this. I don't see a huge need for using this registry if everybody you picked is local. But if you've got folks making decisions for you who are probably going to have to get on a plane to get here, then I would say this is a pretty nice alternative to be able to put into place. And if you're curious, the website is down there at the bottom. It's SOS for Secretary of State, NC.gov. And if you go there, look for the Advanced Directive Registry, and you should be able to find what you need there. All right, I want to stop for just a minute. I'm going to stop sharing so y'all can see my face for a sec. Anybody who has any questions about healthcare powers of attorney before I move on to something else? Oh, come on. I'm doing such a good job that no one has questions. That's unheard of, folks. All right. Like I said, y'all jump in if you have questions. I'm going to move on then to talk about durable powers of attorney. Now, the word durable, we're going to get that to in a second, but a durable power of attorney is for financial power of attorney. And here you're naming someone who's going to make financial decisions for you. It can be springing. So remember springing from just a moment ago on the healthcare powers of attorney. A springing power of attorney goes into effect only after a doctor says you need the help. Personally, I really love that alternative when we're talking about financial powers of attorney, because you're kind of turning your doctor into a little bit of a gatekeeper. The doctor can say, yeah, now it's time for him to have somebody help him balance his checkbook or pay his bills. Or the doctor can say, no, she's doing just fine. You need to step aside and wait until I say she truly does need your help. So it helps to prevent somebody from sticking their nose into your financial business earlier than you really need them to. Remember, on the healthcare power of attorney, I said that the springing portion, when it goes into effect, that's required by law. It's an option on a financial power of attorney. So if you're going to go pull your documents out tonight, one thing to look at is, did I pick the people that I should have picked, or have things changed? And then secondly, do I have that language in there that says, well, whoever I picked can't come and grab my checkbook until my doctor says I need the help. Like I said, it's not a requirement, but I think it's a really nice barrier to put in there, to be honest with you, before anybody can get too involved. A durable power of attorney can be as broad as you want it to, so that the folks you chose can do absolutely everything that you do for yourself from a financial standpoint, or it can be very limited. It can say, my son can only sell my house. My son can only write checks, and he can only write checks up to X number of dollars. So you're 100% in the driver's seat on these. And if you don't have these in place, I encourage you to find an attorney who's going to work with you to make sure that it's not just boilerplate, but it's exactly what you want it to do and what you think is important. And your attorney will help you understand if you're going too far afield, make sure that things are the way it needs to be. I can't emphasize this part enough. The person that you choose needs to be someone that you have absolutely no qualms about this person stepping in and managing your finances. It's not at all, it's not at all unusual for us to have conversations with our clients, and they'll say, well, I guess my oldest daughter should do it because she's the oldest. And then as I ask a few more questions, I find out she's terrible about managing money. She doesn't pay her bills on time. She's filed bankruptcy. Just because someone is the oldest in the family, or just because someone has a history, in your opinion, of managing money, does not mean that they're going to be the best person for the job. So yeah, it might mean that you step on the toes of your other kids. If you choose somebody, you choose the third one down in line because she's an accountant, that's a really good choice. Because if she messes up, she's going to get in a lot of trouble, not just with you, but with the folks that govern her profession. So give a lot of thought to who you choose to make these decisions. I can't remember whether I shared this example last time, but I'll go ahead and share it again now anyway. Without a doubt, financial powers of attorney are the documents that we see abused the most readily and the most often. And we do everything we can to stop that, but sometimes I can't control people's bad decisions. So I had two cases that happened at the exact same time. These folks did not know one another from Adam, but there were two ladies. They were both in the early 90s. They both had financial durable powers of attorney that they had set up years earlier. And in both cases, they had chosen their oldest son to be the person to manage their money. That person's called your agent. And in both cases, the oldest son was not the right choice because these guys cleaned out their mom's bank accounts. One guy used mom's money to buy himself a house. on the Chesapeake and went through about $1 million of her money. The other guy got his mom to sign a power of attorney on a Monday, and on Tuesday, he used that power of attorney to sell all of his mother's land. And it was land that had been in the family since the late 1700s. So it was an enormous chunk of land and it had a lot of value. And in both cases, our only alternative was to sue the sons and try to get that money back. So I know it sounds like I'm telling you something to scare you, and I guess maybe I am a little bit, to be honest, but this is without a doubt the most important decision you're making as far as putting responsibility on someone. And it's critical that the folks you choose are somebody that you have no concerns about whatsoever. You know that this person's going to do exactly what you want them to do. And that might not be a family member. It might not be a child. It might be a nephew or a niece. Think outside the box a little bit. If your immediate family is not the best choices, it's unfortunate if you're going to step on their toes, but you've got to do what's going to protect your assets the best. Another alternative, or a second alternative, is to build some checks and balances into the power of attorney. You can say, for example, if your daughter is the one managing the money, that she's got to report to you on a regular basis on how she's using your money. And if she's not reporting to you, maybe you want her to report to someone else or even to the court. You can put that in there so that you know someone is looking over her shoulder and making sure she's doing it right. You could put two people in. Truth be known, I'm not a huge fan of that because those two people have to work in lockstep. And sometimes that can get a little cumbersome, especially if they don't live near one another. So if the two of them have to go to the bank, they both have to set up the accounts. It can get a little hard, but I can tell you, one of them is probably not going to go too far afield with the other one looking over her shoulder or his shoulder. So it can be a solution. Or finally, you can pick someone who's a professional. There are some lawyers who do this. I don't. I did it one time and I realized it was an enormous job and I never want to do it again. But sometimes CPAs will take on the responsibility as well. So just some things to think about. And when you go look at your powers of attorney, make sure the people you chose are still the best folks for the job. Because things change, situations change. We want to make sure that you've got at least two people lined up, one after the other, and that they are still the right ones that you want doing this for you. So a lot of times my clients will ask me, well, why is it called a durable power of attorney? By law, a power of attorney is only good as long as you have the capacity to sign it, to understand it, and to make it effective. Once you lose that ability, once you become incapacitated, the regular power of attorney is no longer valid. But the word durable and some language that's in your power of attorney fixes that. And it says, even if I become incapable of doing these things for myself, I still want this power of attorney to remain valid. That change that I hope is in your power of attorney, so go look for it. Look for the word durable or look for the word incapacity. Those are usually going to be in there somewhere. And you just want to make sure that the language says that even if I become incapacitated, the person I picked still has the authority to do what I need him or her to do for me. There was a time, actually many, many, many years, when we routinely filed, I'm so sorry, we routinely filed durable powers of attorney at the Register of Deeds office. That's because the law said that we needed to. That law changed about 2 years ago. And with that change in the law, we no longer have to run to the courthouse or the Register of Deeds office and file these as soon as someone signs them. Now, if you have yours, you'll know that it's been recorded if you look on the first page. And usually the middle of the top of the first page, or maybe over to the right a little bit, there'll be a sticker from the Register of Deeds office. And it'll have all kinds of codes and things on it, but it'll have the date that it was filed. So that's how you know that it's been recorded. But know this, we no longer have to do that. We only have to file it at the Register of Deeds if your agent, the person you picked, is going to be doing a real estate transaction for you. So a lot of times that comes up because dad needs to move into an assisted living facility and his daughter needs to sell his house to pay for it. That's a time pretty regularly when we need to file the power of attorney with the Register of Deeds office to make sure she's got the legal authority to do what she needs to do. So if yours has been filed, fantastic. You don't need to do anything differently. If it hasn't been filed, you don't need to do anything differently. But the person that you picked may need to go file it when they need to do a real estate transaction, but no other reason. I didn't put this up here, but the filing fee usually comes out to a little bit less than $30. It depends on how many pages you have in your power of attorney, but most of them come out between probably $25 and $30. If your durable power of attorney has been filed, whether years ago or today, if it's been filed, the only way you can revoke it is to file a revocation at the Register of Deeds office. Basically, it became part of the public record. So if you want to revoke it, we've got to take it out of that public record and say it's been revoked. If yours has not been filed, it's easy. You revoke it by tearing it up, by lighting it on fire, by any way that you can think of to destroy it. That revokes the power of attorney. But that's kind of an important thing to keep in mind. If it's been recorded and you've changed your mind, you can't just do a new one. You have to do a new one and revoke the old one by filing something at the Register of Deeds office. All right, let me stop here for just a minute. It's never a good sign if I'm doing all the talking. Despite what you've heard about lawyers, I don't like doing all the talking.
Hey, Kim, how do you know whether it's been filed or not, if it happened a long time ago?
Yeah, it would. If you've got the power of attorney, you would know because it would have a sticker on the top corner that says it. If you don't have the power of attorney, I love that question, Jane. If you don't, most of the Register of Deeds offices around here have all of that online. And so you can go on or give me a call and I can do it for you. But you can go online and actually pull it up. It takes me probably about 2 minutes to find it and see if it was recorded. I can find it at the Register of Deeds office. And you didn't ask this, but I'm going to add this too. If it does get recorded, or if it was recorded in the past, it was recorded in the county in which you lived at the time that you signed it. So if you used to live in Cabarrus County and now you live in Union County, we'd probably want to check both to make sure it wasn't recorded in either one. Yeah.
Kim, excuse me, you mentioned having two people in line. What about two people together? Is that an issue? I have two sons, and on everything, I put them both. I don't know if that's a no-no.
It's, from a legal standpoint, it's absolutely fine. There's nothing in the law that says you can't do that. From a practical standpoint, it can be a little bit difficult because they both need to sign everything, and they would both have to go to the realtor and sell the house together. But we do it. We do it fairly often. It's not my preference, but it absolutely can be done.
Okay, thank you.
You're welcome. Any other questions about powers of attorney? Nope. All right. How about this one? What happens if I don't have powers of attorney? Or more often, the question I get, what if my mom and dad don't have powers of attorney and never got around to it? So let me go back to put my screen back up here. I have no idea what you're seeing now, but I'm going to just keep doing what I was doing before.
It's working.
Okay, thank you. The alternative, because it happens, you can only sign a power of attorney while you're able to fully understand what you're signing and the impact of what you're signing. So it happens that folks come to my office and they're delightful and I want to do powers of attorney for them, but it's just a little bit too late. You know, maybe some dementia has gotten involved, or Parkinson's, or something that has made it more difficult for them to understand what we're doing. When that's the case, and usually it's the kids that come to me and say, oh Lord, what do we do? Unfortunately, the only answer at that stage is guardianship. So as I put here, it's necessary when this person, whoever we're talking about, is no longer competent and there isn't a power of attorney in place. Now, you might have a healthcare power of attorney and not financial, or vice versa. So we can, and I'm going to cover that in a moment, but a couple of different kinds of guardianship. So it doesn't, we can fit it to the situation. I guess that maybe that's the best way to put it. So guardianship will allow someone else to step in and make health or financial decisions for you, but only after they're appointed by a court. It is, like I said, a court proceeding. And this is what it looks like. It's actually a two-step process. I don't mind telling you all, this is a fairly good-sized portion of the work that we do, but without a doubt, it's the part of my job that really tears my heart out, because I tell my clients all the time, this first part is the hard part. So what we file at the courthouse is a document that has a really long name, but it has a long name because it covers two different things at once. It's called a petition for adjudication of incompetence and appointment of guardian. So what that means is you can't get a guardian until a court has adjudicated or determined that this person is incompetent. And I tell my clients all the time, you and your brothers and sisters can be sitting around the kitchen table and you'll use the word incompetent when you're talking about dad, and it's okay. It's not an emotional thing. But when you're in a courtroom and you hear a judge declare your dad incompetent, that's another story altogether. And avoiding that for yourselves or for your kids is worth everything, in my opinion. But reality is, this happens. So the first part of it is we have to go in front of a judge and present usually medical evidence or testimony to ask the judge to determine, is this person competent or incompetent? Now, if they're competent, they can sign powers of attorney. Great. We're right back where we started and we can resolve it. But if they're not competent, then the court moves on to the next stage, which is the appointment of guardian. So there are three types of guardianship in North Carolina. A guardian of the person is much like a healthcare power of attorney. So that person is making medical decisions and often living decisions. Is my grandmother going to live in an assisted living facility or a skilled nursing facility? That would be the guardian's decision. A guardian of the estate is like a financial power of attorney. So that person is managing all of your financial assets, not just your bank account, but your investments, your house, your life insurance, your Medicare, your Social Security. This person is handling all of those things just like you do for yourself right now. And when somebody needs a person to do both of those for them at the same time, that's the third kind of guardianship. So that's where someone is doing both the medical side and the financial side. And I know I sound so negative when I talk about guardianships, but I've seen how difficult emotionally they can be for families. They're not only emotionally difficult, they kind of get cumbersome and expensive. So with a guardian person, once that person, our individual is deemed to be incompetent or adjudicated incompetent, and a guardian is appointed just to manage their medical and living situation, that's the end of it. The court doesn't get involved again unless something goes wrong. The guardian passes away or becomes sick, the guardian's not doing their job, that's when the court would get involved. But normally with guardian of the person, we go to court, it's finished, that's it. Guardian of the estate, though, the courts are not nearly as generous. The court takes a personal interest and they want to make sure that this person's money and assets are being properly managed. So that means the person appointed as guardian of the estate has to file annual reports with the court saying, here's how much money my grandfather has and here's how I've been spending it on his behalf. The guardian can't sell any of the ward's assets. The person who's been deemed incompetent is called a ward. The guardian can't sell any of his assets unless the court says he can. And when he files these annual reports, he has to pay a fee every time. The court assesses it's $4 for every $1,000. So the court assesses a fee. I call it a tax. They don't call it a tax. But to me, that's exactly what it is. And it's based on the value of what this individual has when they get a guardian. So I show you all this to say it can be a pretty expensive and cumbersome thing to have to walk through that can be avoided real easily just by getting the powers of attorney in place on the front end. Now, most guardianship hearings last about a half day, maybe a little bit less than that. We have had some that are very, very contentious. Maybe grandchild number 1 wants to be guardian, but grandchild number 3 shows up from nowhere and says, wait a minute, you're not capable of doing it. I want to be the one to do it. And then we have to go to court and frankly, let them battle it out until a judge decides who's going to do it. I had one guardianship years ago with a lady who at that time was 91 and she's now 99. So she's still with us and she's doing really well. She lives in South Carolina now. But this is a scary story. I probably shouldn't share it, but she was doing great. She and her daughter had had a falling out years earlier, had not spoken in many years. And the daughter had a change of heart and showed up at her apartment and they reconciled. It was legitimate. I had my doubts, but it was legit. And the daughter said, Mom, I live at the beach now. She lived at Myrtle Beach. And she said, why don't you come down and spend the week with me at the beach? And so she did. Mom, 90, 91 years old, packed up her bag, got in the car, and went to the beach. But she didn't tell any of her friends she was doing this. So the friends became convinced that she had been kidnapped by the daughter. And one of the friends filed a guardianship petition at the courthouse and said, well, obviously she's lost her mind if she would get in a car voluntarily with this daughter that she hasn't spoken to in 15 or 20 years. So what followed was the messiest guardianship I have ever been involved in, because my client was the 91-year-old lady. And I'm telling you, to this day, she's the most competent human being I've ever met in my life. And she had to testify, get on the witness stand in her own guardianship. And the judge asked her, well, what do you like to do for fun? He was convinced that she was just not with us anymore. And her hearing was horrible, and she would not wear hearing aids. So she wouldn't always respond when asked a question. And he took that to mean that she was incompetent. So he said, well, what do you like to do? She said, I like to read. And he says, oh, really? He kind of laughed at her. He goes, what are you reading these days? She goes, well, I'm currently reading a dissertation on the history of the British Republic, and just starts rattling through everything she's been doing, which was so far beyond anything that judge had ever read. So I tell you that to say guardianship is a difficult thing to put your family through. It's a difficult thing to go through. And if you can avoid it, which is pretty easy to avoid, you just do it by getting some powers of attorney in place, that's absolutely the way to go. I'm going to take this down. I know that's probably a shorter presentation than you all are used to, but does anybody have any questions for me about powers of attorney, about guardianship, or we can go beyond that to wills, trusts, anything like that?
I have a question in terms of, say you have a power of attorney in place with a parent, and then you feel like that parent is less than competent. And how can you just exercise it at your discretion, or do you, particularly if they're not in agreement of their competency?
It's really going to depend on the language of the power of attorney, which sounds like a cop-out answer, and it kind of is. So if it's a power of attorney I prepared, we always put language in there about when it goes into effect. It either went into effect the moment my client signed it, or it will require you to get a doctor to evaluate that parent and have that doctor determine whether it's time for you to step in. So the best advice I can give you is take a real hard look at that power of attorney and see if there's a section that talks about when it becomes effective, and that should answer your question.
And then regardless of whether they like it or not, if that's the way the language reads, you're in charge, right?
Yeah, and I'm not going to lie to you, people get angry when, even though they chose you as power of attorney, they may not want you to get involved just yet. And sometimes they'll go find an attorney who won't ask a whole lot of questions, and they'll get it revoked. So I'm not going to lie to you and tell you that it's a slam dunk. If this person is opposing the idea of having somebody help them with their finances or their living decisions, they will probably put up a heck of a fight. But yes, you're absolutely right. What you said is right, that they are supposed to just go along with it because that's the choice they made years earlier when they signed it. But that's not always what happens, I'm afraid. Sorry, Jane, not the answers. Yeah, I'd love to be able to tell you that it's a little more definitive, but it's really not.
Yeah, okay, that makes sense. I've also, I guess, and you can download some of these things. I know if you're doing wills and estates, it makes sense to do it all. I would do it with a professional, but like in this case, I recognized during COVID, you know, like all of a sudden I'm more worried about my college age kids or anybody 18 plus than I had thought about it before. Normally I don't think when I was young, we did any of this stuff. It's when you get older that you start, or when you have children, you start putting this stuff in place. But I guess now I feel like it's something that to be addressed for anybody, because with COVID, sometimes you go into the hospital and you don't have people, maybe I'm speaking healthcare, but because my kids really don't have anything financially, but except for debt, that's mine. but you can download, if I'm correct, I think it's you can download these things and do that, correct?
Yeah, absolutely, yes. So let me address a couple of things that you said. There are a couple of sites where you can download forms for powers of attorney. I can't tell you whether they're going to be valid or not because it just depends on the form and it depends on the site. The legislature of North Carolina has pretty good forms. Actually, they've created the forms. So if you have to go that route, that's not a bad way to go. I'll tell you very candidly, a lot of folks have heard of LegalZoom. LegalZoom's powers of attorney are not terrible. Their wills are atrocious. I'm just being honest with y'all. We make more money after someone dies if they had a LegalZoom will because it takes so much work to get it cleaned up than it would have cost to just let an attorney do it from the beginning. So LegalZoom's powers of attorney, not terrible. LegalZoom's wills, please avoid them at all costs. You will end up costing your estate a fortune otherwise. Jay, you mentioned COVID a couple of times, and I appreciate that because I should have addressed that as well. Governor Cooper has put a couple of orders in place, as has Sherry Beasley, who is the Supreme Court Justice of North Carolina, the Chief Justice of North Carolina. And right now, we have kind of a unique opportunity, and I don't know how long this will last, but I encourage y'all to take advantage of it. If you're not comfortable going to an attorney's office right now, everybody absolutely understands that. There's actually a pretty good mechanism in place where we're doing a lot of our consultations by phone and by Zoom, just like this. Then we send you the documents, you tell us what needs to be changed, and then when everything is good, we can actually have you sign it right where you're sitting right now. We do it through Zoom, and then you send the documents to us and we'll notarize them when they come back to our office. This is something that the governor and the Chief Justice put into place because of COVID. So I don't think it's going to last forever, but it's a really nice, convenient way to get these documents put in place without ever having to leave your home.
Oh, that's great.
It really is. It's kind of awkward for us, to be honest with you. We've had to learn a good way to do it, but we've come up with a really good system, and we're doing a couple a week right now where folks just are not comfortable coming to the office, and we respect that.
Well, it's hard to get notaries anyway right now.
Yeah, it really is. We usually do our document signings here, and we actually have a table set up. We have, I told you we're in a historic house, so we have a wraparound porch. So we have a table set up outside for folks who want to come to the building, you don't want to come inside. And then some folks are coming in, and then we're doing a lot of the notarization by video right now.
Great. That's great to know.
Thank you.
Because the banks aren't managing notarization very well at all, in my experience.
And I'm told, this is coming from my clients, but I'm told that a lot of banks will not notarize anymore. They will not notarize estate planning documents, which is what these are. I'm not sure what the rationale is there, but that's what I'm told. And so you all know, if you ever have a document that needs to be notarized, and just like you're doing a car title, you're always welcome to stop by our office and we'll do that for you. We don't charge anything for that. It takes us 2 minutes. So just feel free to come by anytime and we'll take care of it.
That's lovely. Thank you for sharing that. That's great.
Absolutely.
All right, does anybody else have any questions? There's, like I said, you don't really think about these things until sometimes you need them, but hopefully everybody recognizes the value and the importance of them. So, and while we have Kim here, feel free to ask any questions that relates to estate planning, wills, documents, power of attorneys, any of that.
Can I don't know if this is working or not, since I have never done this before. Can you hear me, Jane?
Yes. Yes.
Okay, I have I guess a comment, my experience. My mother died not that long ago, and she had, it was that health document saying, you know, she didn't want anything extra to be done to save her life. And so, you know, she signed it and did all the paperwork. So I brought it into her, or into the hospital, and gave it to them, to the nurse. And they basically told me that we had to make the decision as to whether or not to keep her alive or to, you know, let her die or whatever. And I was really shocked by that, since it supposedly was so important that she fill out all this paperwork, that it really made no difference with what she desired.
Yeah.
So I'm interested in your comment.
I'm sorry that you and your family went through that. I agree with you. If she had completed that paperwork and it was pretty clear what she wanted, I would have expected the hospital and the doctors to abide by that. So I'm so sorry that you all had to deal with that, because that,
Yeah,
yeah, that undid everything she intended, I'm sure.
right.
Is there any recourse in that scenario, Kim, where you can,
Well, with her mom having already passed, the only recourse would be for her estate to bring a claim or a lawsuit against the hospital or against the doctor. And in reality, they probably won't get real far with that unless they can demonstrate that because the doctor didn't listen to mom, mom lingered and mom was in pain. I mean, you'd have to demonstrate that there was a negative repercussion that created an unfortunate or an unpleasant situation for mom. So yeah, there could be some recourse, but the reality is I'm afraid there probably wouldn't be much of anything that would come from it, which is wrong.
Well,
It's very wrong, but I think it's true.
well, I don't think my mother really had an opinion at that point, because we didn't really uh, discuss it with her, because of her situation. And it's just that I guess I didn't realize that basically it was left up to me to decide, do we keep giving her oxygen day after day when her oxygen level was so low and she basically was just slowly dying.
Mm.
And, the hospital wants you to go ahead and make a decision to cut off the oxygen or leave the oxygen on. And it's such a difficult decision. Anyway, I was just surprised that really the piece of paper that she had filled out really, I guess this is a policy in, a major hospital here in Charlotte that, anyway, thank you.
Well, it shouldn't be a policy, and I really am very sorry that you all went through that.
Yeah.
Fortunately, getting these things in place sometimes is only half the battle, because it does later involve battling it out with the doctors or the hospital or the assisted living facility to get them to listen to what you've said. That
Mhm.
kind of defeats.
Yeah.
Yeah, it's unfortunate.
Yeah.
anybody else have any questions today?
I had,
Anything?
I had a situation that was more complicated than I thought it should be when I had all my paperwork done. And my husband was in an accident and was in the hospital and was having to be moved to rehab in a nursing facility.
Okay.
And so they asked that I come out there, get there the morning before they were moving him, so everything would be in place when he got there and do all the paperwork. And I thought the questions, because we had signed the paperwork and I had the health power of attorney and I had the whole folder with me. But the specific questions they asked about what do you want done, if this, if that, I thought were much more than I had anticipated, and more difficult to deal with. And he wasn't in a life or death situation. It was more of a bad injury and surgery and repeated surgery and rehab. It wasn't like his life was in danger at this point. However, due to the surgery and anesthesia, of course, he was not coherent at that time. But I just was not prepared for that, and I wish I had been a little more prepared.
Now, I will admit I've heard folks tell me that before, that though they have these documents in place, they get to the hospital and they just get quizzed on everything that really is already addressed in the documents, or often addressed in the documents. I wish I had a good solution for that. If I could control the doctors, I'd be a very wealthy woman. But yeah, it's just a little ridiculous. They often will not acknowledge these powers of attorney, and you have to just fight them like crazy. On the other side of the coin, we're finding more and more banks and financial institutions try to argue that they don't have to take financial powers of attorney. And so the legislature just into early 2019, when they made some sweeping changes to the law, they also put language in there that says anybody who refuses to accept a financial power of attorney has to pay the costs of the person who's trying to get you to take it, and may get civil fines or criminal time in jail. So that has been really helpful for us, because it's always Wells Fargo. And every time Wells Fargo refuses to take a power of attorney, we just whip out that statute and say, okay, here, now you're going to take it. But there's not something comparable on the medical side. I'm hopeful the legislature will look at that and make some changes, but it hasn't happened yet.
And I didn't feel like they weren't honoring it so much as that it was much more complicated than it should have been. The what ifs, things I didn't expect to be asked, especially when I wasn't in a life or death situation.
Yeah, I agree with you. That does seem a bit much.
And then that was dealing, of course, with the nursing, facilities. So that's a little bit different than a hospital, I understand.
Yeah, that's true. They see all kinds of things there, I'm sure.
All right, do we have any other questions today? Thank you for sharing. If anybody has any experiences they want to share that of just things that other people need to look out for, if you've had any experiences one way or another, because sometimes we learn from each other. All righty, well, it sounds like that we've gotten a lot out of this today. I know it's a lot for me to think about. I'm going to rethink what I have just recently done. And I'll probably be in touch with you, Kim. That I totally wasn't really, from my kids' standpoint, it's like not something I really thought about till just COVID, but I might want to make sure that I've done it the right way. If I decide to do it, I might as well make sure it's done the right way.
I'll be happy to help.
Okay, all righty. Well, I thank you so much for being here. It was really nice to have you, and it's always good to learn more and just double check these documents that we have and make sure they're up to date and they still represent what our current wishes are, because sometimes things change from when we put these in place originally. So I think that's a really good reminder for us to pull out these documents and dust them off a little bit. And then just to make sure that the people that we're also responsible for, we know what their documents look like. So thank you so much for making us, bringing that top of mind for us. And just a little promotion for next week. Next week we'll have Parks and Recs coming on. So there's lots of, the weather's beautiful. We need to be outside as much as we can. So it's really important that, you know what our options are around town that are here. And I have just recently discovered a few new places I didn't even know existed. So I'm excited to hear what they have to say. So I hope to see you next week, same time. Hopefully you're all getting my Monday emails, and if you're not and you want to, please reach out to me if you're not on my email list. But again, I'm glad to be here with you guys every week. If you have topics you want to see, please don't hesitate to reach out, and I'd be happy to research an expert like Kim to come speak with us. Once again, Kim, thank you so much for being here with us. I appreciate your time today. And again, it's Garrity and Gossage and Matthews. If anybody should be looking, feel free to reach out to me for contact information if you can't find it. But we have worked with her personally besides the Y talk. So I speak very highly of their services. It's been really helpful for us. So thank you all so much. And Kim, thank you.
Thank you. Thanks for having me. I appreciate it.
Okay.
Thank you.
All right, y'all have a good week. Hope to see you next week. Tell everybody, tell your friends, bring them in. Love to see you again.